The one that's on behalf of the, or dealing with plaintiff in the City of Henderson. I haven't received any papers.
Your Honor, I'll let Mr. Cate speak to that, but we have resolved that case. I just sent over a stipulation order for dismissal to their office to review, so you should be receiving papers shortly.
Okay, very well. So the remaining motion is the defendant's special motion to dismiss NAPSO's complaint. Right? Go ahead.
Your Honor, again, thank you, Matthew Cate, for the Review Journal. I think it's important to start by considering how we got here and what this case is about. This case is about the peace officer union's attempt through the court to tell the Review Journal how to publish news and information of a public concern. It filed, as the court may recall, 3 months ago, this lawsuit in response to an article that the Review Journal published identifying challenging staffing issues at the Henderson jail and the issues that flowed from those staffing challenges, budgetary concerns, how it impacted conditions at the jail, officer safety and health, inmate safety and health, those kinds of issues of core importance to the public who are funding the jail and concerned about its operations. NAPSO sued because it didn't like that the Review Journal, in connection with that article, published images and footage taken from the jail that the Review Journal lawfully obtained through no wrongdoing on its own. NAPSO didn't like those images being public, and it brought this action. And as such, this case is exactly the type of case involving the type of claims and the type of speech that the Nevada legislature several years ago had in mind when it expanded the state's anti-SLAPP laws and made them some of the strongest in the country. Those laws are designed to protect and give breathing space for the public to talk about these types of issues without concern that they will be...
The talk did take place, right? I mean, they're not contesting what was said.
Correct.
They're contesting the video. The blockage of the faces.
Right, correct. And the idea behind the anti-SLAPP is that you want to have the breathing space by applying the anti-SLAPP statute broadly to conversations about issues of public importance that may, within those, implicate issues that a plaintiff may challenge and take issue with. And so the analysis that the anti-SLAPP statute requires is, and because the purpose of the anti-SLAPP, to finish this thought, is that the courts should have a path to make an initial early assessment of the validity of the plaintiff's claims when they are going after, or when they involve and implicate speech on issues of
Well,
public
would the
concern.
issue of the application of NRS 289.025 be one of public importance?
With the issue of the
The
application.
application of that statute.
The application of the laws are generally of public importance, for sure. I mean, just as the application of the anti-SLAPP statute or the protections of the First Amendment, what happens in a courtroom, claims and defenses, what happens, those are issues of public interest. But the anti-SLAPP statute requires a two-part analysis that separates the merits discussion from a discussion of, is this the type of proceeding that requires this early determination? So there are all manner of procedural protections in the anti-SLAPP statute that say, let's get to the chase. If this is the proper claim and proper activity that's protected by the anti-SLAPP, let's have the plaintiff show a probability of success on the merits. And so the first step is to take an analysis that's divorced from the merits on the question here is the Review Journal's conduct that gave rise to this claim, is the conduct protected by the anti-SLAPP statute such that the court can now look into the validity of the claims? And that analysis looks broadly at the publication the Review Journal made. It looks at what was the speech. It doesn't look at the granular issue of what does NAPSO challenge, what aspects of the article is it challenged. Cases after case that we've cited in our briefs from the Ninth Circuit applying California's anti-SLAPP statute, which the Nevada Supreme Court says is persuasive when construing the Nevada statute, Court of Appeal decisions out of California, and even a case in the Federal District Court here in Nevada applying the Nevada statute, over and over show that when you do this first step analysis, you look at the broad issue of public interest in the article, the defendant's conduct, not the characterization of the claims by the plaintiff, not the granular aspect of the article that's being challenged, but is the speech overall by the Review Journal here an issue of public interest?
Okay, for the record, I want to make it clear that when I heard the motion for preliminary injunction, I did not consolidate it with trial on the merits.
Correct.
Right? Okay.
Correct. And so, there is a similar, later, discussion about the merits that we'll get to after I want to discuss the showing that we make to explain the applicability of this anti-SLAPP provision. And that showing is a three-part showing on our part. One is, again, was the article as a whole published, and did it concern an issue of public interest? And the second issue is, was the article published in a public forum? And the third is it truthful or published without knowledge of falsity? And just to take those in reverse order, NAPSO, in its papers, acknowledges that it's not challenging the veracity of the publication here or the images. So that fact is established. It's not challenging, realistically, it's not challenging that the article was published in a newspaper, that it was published online. These are public fora for the purposes of the anti-SLAPP statute. And so then the remaining question for this initial part of the court's determination today is, was this speech by the Review Journal, broadly speaking, looking at the article, about an issue of public interest?
Well, I understand that, but I'm looking at the complaint. I think that's the operative pleading. I don't think it's been amended, right? It's the
Correct.
original complaint. There are two claims for relief. One is for declaratory relief, that's the first cause of action. The second one is for injunctive relief, the second cause of action. I denied the motion for preliminary injunction again without consolidating the trial on the merits. But as I look at the first cause of action, the claim for relief, paragraph 31 indicates NRS 289.025 governs the confidentiality of the home address and photograph of peace officer in possession of law enforcement agency, et cetera, et cetera. In other words, it's seeking a declaration as to the applicability of NRS 289.025 or ETSEC, right?
Right.
That's what's being sought here. And you're in effect contending that the plaintiff can't come into this court and seek a declaration as to the applicability of that statute.
Well, Your Honor, they can of course raise those claims. We're into the merits here.
What you're saying, in effect, is that they should be punished for doing so on the anti-SLAPP case.
The anti-SLAPP, as the legislature wrote it, and as the Supreme Court of Nevada earlier this year, actually just last month, explained, applies to any claim for relief arising from activity that is protected by the anti-SLAPP statute. And so any claim, it's not damages claims. Panic versus TMM Incorporated is the case from just last month where the Nevada Supreme Court said, to determine whether the anti-SLAPP statute applies, you look at what the defendant was doing, not the claims for relief and how they're characterized. And so it's a separate consideration entirely that they're seeking declaratory relief versus, for example, damages for invasion.
Well, I understand that, but the relief they're seeking is pretty limited, it seems to me, in the sense that it's just seeking to say that the faces of the officers should have been blocked.
Well, a couple of points on that, Your Honor, is that one, that claim arises out of the publication of the article. If there was no article and if the video wasn't published, there would be no claim for declaratory relief here. That claim arises out of the protected activity of the Review Journal, so the anti-SLAPP statute applies. Then we get into the merits discussion. And second, on the issue of whether it's a small issue, it is, and this is, I can't stress this enough, this is a gravely important issue when a party asks the court to declare the manner in which the defendant spoke is unlawful and that they can't speak that way, either in the future or in how they did it. Now, I don't know, NAPSO is purporting to say that they're no longer seeking injunctive relief. I take them at their word, But they're seeking declaratory relief to say the manner in which the Review Journal published this information is unlawful and a violation of the law, that their speech broke the law. That is fundamentally an issue for the anti-SLAPP when the speech implicates issues of public interest, as it does in this case. And so the anti-SLAPP statute looks at what the defendant did, not the nature of the relief that the plaintiff is seeking. And that's written into the statute and analyzed and explained by the Supreme Court of Nevada just last month, most recently. And so it's a separate analysis. Again, the merits is separate from does the anti-SLAPP statute applies. And once we're in that territory, because you have protected activity by the defendant, you are now looking at, well, what's the merits of the claims?
Again, this is an anti-SLAPP motion. This isn't just a 12b5 motion.
Correct. The burden, once we prove to Your Honor's satisfaction that the activity is protected by the procedures of the anti-SLAPP statute, the burden shifts to the plaintiff to make whatever showing they can of prima facie evidence that they have a probability of success on the merits. Here, I think it's generally understood by the parties that there's no issue of fact. These are issues of legal interpretation, of statutory interpretation, of application of First Amendment defenses. And so, we've actually kind of already tread this ground on the legal issues of the application of the statute. Of course, the court's ruling was not, binding on it today. NAPSO was able to, and has the burden of having come up with arguments to present to the court to explain why the statute allegedly reads the way they read it, how it fits their application of the statute in this instance would comply with the Peace Officer Bill of Rights intent the legislature had in enacting those provisions, and finally and not least, how that application of that statute could be compliant with the First Amendment. That's their burden to explain those issues. And Your Honor, the arguments that they've asserted in their papers and they'll reassert today are the same ones the court has assessed before. The framework of that statute make it clear that the Peace Officer Bill of Rights does not apply to the Review Journal because it doesn't employ peace officers. It's not a law enforcement agency. And as the Nevada Supreme Court has held several times, that statutory framework and the pieces in it govern the relationship and the responsibilities and rights between the peace officers and their employers. And you look at the judicial relief provision, it says that the limitations of what the court can do, the relief that the court can provide for a violation of Chapter 289, including the provision at issue in this case, is to provide relief to the aggrieved peace officer by enjoining the agency that employs them, their employer, from further violations of 289, Chapter 289. The Review Journal is not an employer of a police officer or a peace officer. It has possession of images that are in its possession, they may be in the possession of a law enforcement agency, but the statute doesn't say what NAPSO wants it to say, which is as long as the law enforcement agency has possession of images, no one can ever publish them, no matter how they obtain them. And that's not what the statute says. It's not what the statute was meant to do. And most importantly, the First Amendment prohibits that type of application.
Paragraph 37 of the complaint states, the court should decide whether the LVRJ's interpretation of NRS 289.025 constitutes a violation of the statute as a justiciable controversy exists between NAPSO and LVRJ. NAPSO's members have a legally protectable interest in the controversy and the issue presented is ripe for judicial determination. End quote. So they're seeking access to the court, basically, to make a declaration as to the applicability of that statute. And of course, they're contending that access to the court is very important, as is public information, the First Amendment.
Yeah, and when we acknowledge in our papers that they can ask, anybody can ask the court, what are my rights under this statute? And the answer is you don't have any, as NAPSO. NAPSO specifically doesn't have any because NAPSO is not a peace officer. To the extent that NAPSO is trying to make associational standing, based claims on behalf of its members, we've noted that they've not provided the information, as the court noted in its preliminary injunction order, that the identities of the officers at issue is relevant to this case, is relevant to that determination, because there is the issue of authorization and consent. But they of course can sue to ask the court, what are our rights? But they have none. And when they sue, asking what their rights are with respect to the publication that the Review Journal made, that triggers the anti-SLAPP law because it arises from our publication on issue of public interest. And I'm happy to answer other questions, but I mean, I think ultimately, you know, the anti-SLAPP consideration and how it applies is a separate question from the merits. And we submit that this is exactly the type of case when a party sues a speaker over their speech because some part of it allegedly violates some law. Even if they're just seeking a declaration that it violates that law, that triggers the anti-SLAPP. And so then we're in merits territory. And for all the reasons we've just discussed and we've discussed throughout this case, the statute cannot be applied the way that can't be read the way NAPSO reads it, can't be applied the way it asks the court to do.
All right, thank you.
Thank you, Your Honor. And I think you anticipated some of my arguments here this morning. Counsel didn't get into the standing argument in too much depth, so I won't belabor our argument and our opposition. I would just note for the record, though, that it's important that we know that a dismissal for lack of standing, as Your Honor asked, is this a 12b-5 motion? It's not. It's a special motion to dismiss under Chapter 41. Whether a party has standing is, of course, a question that goes to the court's jurisdiction, right? So that's whether the court has the fundamental power to grant the requested relief. As standing concerns jurisdiction, a dismissal for a lack of standing is most often without prejudice because it's not an adjudication on the merits, right? So we need to look at NRS 41.660 subsection 5, and I quote, "If the court dismisses the action pursuant to a special motion to dismiss filed pursuant to subsection 2, the dismissal operates as an adjudication upon the merits." So just for the record, if the court were inclined to dismiss this action based on standing, it wouldn't be on the merits and it wouldn't be pursuant to NRS 41.660. More importantly, though, where Your Honor was going in the fact that there's the only claim remaining is the declaratory relief claim, that hits the nail on the head. Your Honor denied our application as to both the TRO and the injunction. That claim is dead. Upon that order being issued, the scope of the lawsuit fundamentally changed. Now we're no longer looking backward at the article and the video. Now we're only looking forward. The court's interpretation of the statute will only be applicable to future communications that we would contend violate the statute regarding the officer's private information. Pursuant to NRS 41.660 subsection 2, the RJ could have filed its special motion to dismiss at any time within 60 days of service of the complaint. It did not do so until after Your Honor issued your order denying injunctive relief. So again, at that point in time, all that remained was the declaratory action. And by extension, the lawsuit no longer concerns any existing communications in the RJ. It concerns the parties' competing interpretations of the statute. Getting to the scope of NRS Chapter 289, as to the Peace Officer Bill of Rights, counsel classifies that chapter as only applying to peace officers and their employers. Well, we pointed out extensively that some statutes do, some statutes don't. I won't list them all, but in our briefing on both the injunctive relief and opposing a special motion to dismiss, we pointed out numerous statutes under NRS Chapter 289 which say a law enforcement agency shall do this, a law enforcement agency shall not do that. That's in some of the statutes. It's not in all the statutes. We also cited to NRS 289.085. That statute concerns what an arbitrator or a judge can or cannot do in relation to the peace officer's rights. Another statute that isn't limited to peace officers and their employers is NRS 289.110. That applies to the district attorney and the attorney general in analyzing peace officers' Bill of Rights. So it's LVRJ, the RJ's one-size-fits-all classification of 289. It's just not applicable if you look at the individual statutes. Just briefly, the cases cited in the reply, they don't concern, or at least based on my review of them, they don't include a comparable statute that says this information is confidential and not for public dissemination. So they're distinctive. Right, so the legislature's intent, the question the court needs to ask is, why would the legislature enact a statute that sets forth in explicit language that a peace officer's home address and photos of the officer at work are confidential and not for public information if it only intended for that statute to apply to a law enforcement agency? That defeats the whole purpose of enacting the statute to begin with. Another aspect I just want to make for the record that wasn't touched on in the briefing is that under NRS 41.663F, the court was to rule on a special motion to dismiss within 20 judicial days of service on the plaintiff. That's not happening here. The motion was filed and served on October 31st. The notice of hearing was set for December 7th. 20 judicial days would have been November 30th. Today is 35 judicial days from filing. Just to the extent that, I know the RJ plans to request its attorney's fees and the $10,000 penalty provided for in NRS 41.671. So if we're going to take a strict construction of the statutes under NRS Chapter 41, then we should take heed of the timing statute as well. But again, the fact that the motion was filed after the injunctive relief cause of action was ruled on changes the landscape of this lawsuit. There is no looking back. There are no communications at issue. The only issue is one for declaratory relief as a general prospect whose interpretation of the statute is correct. Anything the court decides moving forward is not going to impact the article and the accompanying video as it currently exists. So therefore, the question of law before the court has no impact, and it doesn't need to look at any existing communications online or in the RJ. So that's where we stand from the lawsuit. The special motion to dismiss. The timing of it defeats it based on the claim that's remaining.
All right, thank you. Pastor.
Thank you, Your Honor. As to the timing, it's not clear if NAPSA is arguing that we didn't fall within the 60 days of service of the complaint. I don't think we've actually technically been served the complaint, but we fell within the 60 days. We filed and of course, respected the court's timing of setting the hearing under the court's docket. There's nothing about the timing of this hearing that undermines the applicability of the anti-SLAPP statute. The fact that NAPSA says the complaint is now different than it was doesn't change the fact that the complaint is what it is and was brought for the reasons it was filed. And the reasons it was filed was because the Review Journal published an article on an issue of public concern. And they want to take issue, they want the court to rule on the Review Journal's interpretation of NRS 289.025.
And I think it goes to is the blocking of the faces in the video, right?
The only thing...
Not the substance of the communication.
Their argument is that the statute somehow gives them a path to have the court require us to block the faces.
The faces, that's all.
That's their assertion. But that's about the images. The interpretation of the statute literally is about how these images came about and how they were published, what context they were published in. So the claim for declaratory relief here, it doesn't just, we're no longer talking about, well, can this maybe apply in a context academically whenever some member of the public obtains an image of an officer that was exclusively, but no longer exclusively, was in the possession of a law enforcement agency. That's an academic issue that the court is not to address unless it's grounded in an actual controversy. And what's the controversy here? The controversy here is that the Review Journal published images in connection with this article. And that's what this suit is about. And NAPSO now can say, well, now things have changed because we're only just seeking some kind of prospective future guidance from the court on how the statute might apply theoretically in the future. I don't see how that's a justiciable controversy. But if it is, it's justiciable only in the sense that it arises from the publication of these images at issue. And that is how this becomes an issue, that this complaint arises out of this speech by the Review Journal, and it has to be analyzed under this anti-SLAPP context, and then flowing into the merits discussion. And so the timing of that we brought this anti-SLAPP motion within the time provided by statute, the fact that the complaint says what it says to date, it's not been amended, it's not been revised, it's not been, the officers haven't been added to it. The complaint arises from the speech, and we are seeking a motion to dismiss the complaint that is in front of the court now. And that NAPSO is now trying to recharacterize its claim is not to affect the anti-SLAPP analysis. The Supreme Court just last month, in that case I mentioned earlier, Panic versus TMM Incorporated, said it's not about the claim for relief and how it's characterized. The anti-SLAPP statute applicability depends on what the defendant's conduct was that gave rise to the suit. The court would have no reason to consider this prospective future conduct guiding request that NAPSO is making today. It would have no reason to consider that if the Review Journal hadn't published those images in connection with the article about issues of public concern. That's why the anti-SLAPP applies. On the merits, they mentioned Nick Meyer and the conversation that court had about the language and how maybe it applies to arbitrators and doesn't apply, the other statutory arguments that NAPSO is making. Nick Meyer explained that when you look at the statute, it applies to some employers of some officers, and some aspects of it apply to employers of other types of officers. And the plainest and most obvious reading, the court said in Nick Meyer, was that Chapter 289 involves a relationship with employers and peace officers. Excuse me. And the statute itself, the fact that there are provisions that are procedural in nature, NAPSO just mentioned an Attorney General one relating to preparing investigative reports. That doesn't govern the conduct of the Attorney General. The judicial review provision doesn't govern the conduct of the courts. The evidentiary provision doesn't govern the conduct of arbitrators in the courts. These are procedural and evidentiary protections that the legislature wrote into the Peace Officer Bill of Rights, intended to give force to the provisions that govern the responsibilities of the law enforcement agencies who employ peace officers. Everything about the Peace Officer Bill of Rights applies to the government agencies that employ it. The nature of the Bill of Rights, it's in the name, the Bill of Rights protects people typically from the government activity, and these rights are intended to protect officers from the law enforcement agency employers, not the newspapers. And so the arguments that the statute ought to be stretched, fall on the face of the statute itself. I will mention that counsel just mentioned that there were no cases discussing, the confidentiality of statutes and how, that's supposed to be important to the court's analysis. Bartnicki versus Vaughter is the Supreme Court case where the Congress of the United States and the legislature of the state of Pennsylvania made a legislative determination that private conversations between two people on the phone are private and confidential. And if you record them, you violate the law without consent. And if you release them and disseminate them, you violate the law. These are legislative determinations of important public policy from the legislature's point of view. The Supreme Court of the United States said that doesn't matter whenever you have an issue of public concern and a newspaper or a member of the public who obtains that information without breaking the law, the First Amendment the statutory determinations of what's important, what's confidential, have to give way to the First Amendment when First Amendment considerations are at stake, as they are here. And with that, Your Honor, I mean, any other questions, I'm happy to
Okay,
answer.
thank you. I denied the motion for preliminary injunction, right? However, having done that, I'm not going to fault the plaintiffs for seeking access to the court for an interpretation of NRS 289.025 and other applicable statutes relative thereto. That being said, all things considered, I'm denying the motion, the anti-SLAPP motion to dismiss. That's without prejudice to proceedings under 12b5 or 56 or whatever. Okay. What I'm going to ask is that council submit proposed competing orders if you can't arrive at an agreed upon order. All right.
Thank you, Your Honor.